it comes to diversity in our profession, we've been talking for decades that it's the right thing to do, it's a smart thing to do. Companies that embrace diversity have seen better results, and yet our profession remains stubbornly one of the least diverse out there. Challenging the status quo and arguing that perhaps our ethical requirements should be changed in order to move the needle on diversity is David Douglas, who is the managing partner of the DC office of Shepard Mullen. Please welcome David Douglas. Thank you.
For as long as I've been practicing law, we have all been on this same journey together. We have been trying to achieve a diverse and inclusive legal profession. And we've made some progress, but I think at this point we're all more frustrated by the lack of progress. We've taken different paths. We've taken the moral route. There's been the business route, the business case for diversity. But what I want to talk about today is an ethical route. Now, to review quickly these different routes, the moral route, that's because it's the right thing to do. We did that for a while, we argued about that for a while, but we found it to be frustrating and ineffective. And why? Well, if I could just get a show of hands, how many people here think they're immoral? And just morals are broad, acontextual, subjective value systems. You and I can violently disagree about things like abortion or the death penalty, but we can still agree that we're moral people. Or I can decide you're not moral, but you don't care what I think. So it doesn't really have a lot of force to cause action. So then we went to the business route, the business case for diversity. And that essentially said, because our clients are demanding it. And what was effective about that is it reframed the debate about diversity from one that was controversial and potentially divisive to one that was based on a shared value. Because if you are in the private practice of law, the one thing we all value is client service. And so if a client wants it, we do it. We got to use their billing software. What are you going to do? They want us to buy a table at a dinner. Well, what are you going to do? They want us to hire a lot of people of color and gay people. Well, what are you going to do? And so we responded to that, and it has made a difference. But it's not a panacea. It has its limits. One of the limits, I find, is that it turns diverse people into commodities. It says you're only here because they're making us have you here. Any wonder that we're having such retention problems, right? Well, you can be here, our clients want you here, but for that, The second problem I think it creates is that it relieves us of our responsibility to promote or to advance what is generally a shared social value, equality. Because the business case for diversity says at my law firm, I'm only doing it because my client's making me. Now, what does the client say? Well, we're making you do it because our customers are demanding it. No one takes responsibility. Someone else is forcing us to act. And on a smaller note, it creates a division between the law firms and their clients because, frankly, we get a little frustrated that our clients are making us do stuff that they're actually, in all cases, not really doing. So I want to talk to you today about the ethical route, and let me tell you where it started. It's been a long path for me, looking at the rules of professional responsibility and what they address and what they don't. The rules of professional responsibility, until 2016, believe it or not, the ABA rules of professional responsibility did not say it was a violation of the rules to discriminate. What they said was it was a violation of Rule 8.4G, conduct prejudicial to the administration of justice. In the comment to the rule, it said discrimination may be an example of something that is prejudicial to the administration of justice. Quick question, give me an example of discrimination that is not prejudicial to the administration of justice. It wasn't until 2016 that the ABA elevated that rule. And when I was thinking about that, it made me think, well, where do our rules come from anyway? What is the actual source of our ethical obligations. Who gets to say what they are and what they do and what they address? And that's what I'd like to share with you today briefly. I'd like to take you on that journey, talk to you about what I found, and then I want to talk to you about what I think is the next step on this road, which is that we should have a new model rule for professional responsibility that recognizes the legal profession's long-established responsibility to promote equality in society. Now, notice I didn't say it's time for our model rules to call for us to do it or to impose the obligation to do it. It is to recognize the obligation. And the case I want to make for you today is that we have had a long-standing common law obligation to promote equality in society that our rules have not addressed. And Martin Sinclair, last night at dinner, talked about making change in a profession that values incrementalism and precedence. And I want to make the case that, in fact, such a model rule is not a great leap. It's the next incremental step on a path we're already on, and it's amply supported by precedent, legal and historic. So let me talk about that. So our next stop is proposed rule 8.5. So now, why an ethical case? Why is it different? So unlike morals, ethics are externally imposed contextual codes of conduct. We can make people do things through ethical codes, lawyers, physicians, others. Ethical standards ensure uniformity, they're compulsory, they're enforceable, and ultimately, they can be codified. So then the question I asked was, well, I didn't even know where our rules of professional conduct come from. We talk about lawyers' ethics, but the rules are model rules of professional responsibility. I didn't even know how those two things were different. So I started to dig back, and the question is, where do our rules come from? Well, they come from this guy, David Hoffman, who in 1836 wrote 50 resolutions in regard to professional deportment. David Hoffman is considered the father of legal ethics. This is the best image I could find of David Hoffman. Although I suppose if it was billable, I'd have looked a little harder. So here are his rules. They're pretty vanilla. I will never permit professional zeal to carry me beyond the limits of sobriety and decorum. I will espouse no man's cause out of envy. To all judges, and I know you're here, that's why I didn't stop the list at 2. To all judges when in court I will ever be respectful. They are the law's vice regents. And yada, 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 on through to 50. That's where they come from. But there were lawyers practicing law before 1836. So why does David Hoffman feel a need to write down some rules in 1836? So I looked a little bit more, and I found this guy. We know who he is, right? Thomas Jefferson, just in case you're wrong. So in 1773, Thomas Jefferson writes an open letter to his community. And what he essentially says is, I'm not taking any more cases unless I get paid in advance. And he's complaining here, he's whining about people who are taking advantage of him. Well, that's kind of curious. What is going on that Thomas Jefferson has to write this open letter to the community? Well, what was going on? At that time, there was no mechanism for lawyers to sue to get paid. For a lawyer to sue or attempt to collect a fee was considered unseemly. And why is that? Because in our original account of lawyers, we were the keepers of the flame. We were considered above self-interest, in contrast to business people. We were charged with maintaining and pursuing the common good. That's what we did. We didn't sully ourselves with commerce or business. So what is America's common good? This is pretty obvious. Declaration of Independence, the Constitution, the Bill of Rights are founding documents that define collectively who we are in this country and what we believe and what we are committed to. Thomas Paine said, so far as we approve of monarchy in America, the king is law. Well, what good is a king if you don't have any knights? So who are the knights for the king in our country? We are. That was our duty, to preserve and defend our social values. That is why the doctrine of judicial review got so much traction so quickly, because it was recognized then that was the lawyer's exclusive province to interpret what our laws and values and our founding documents mean. All right, things changed. We went from being knights to mercenaries, right? While the first role of lawyers in society was selfless pursuit of the common good, the second was lawyering on behalf of individual clients. And that's what David Hoffman and Thomas Jefferson were wrestling with. How do you balance that private interest against the public good? David Hoffman felt a need to set up rules. And so now, for example, if I represent someone accused of murder, I can advocate for them competently, not zealously, but competently. I still have to be civil, but my obligation to represent them doesn't overwhelm my obligation to represent the public good, because there's a prosecutor and there's an impartial judge. And together, by framing this system, the profession as a whole discharges its obligation to serve the public good. Now, I've actually not said anything all that controversial. The ABA model rules recognize that as a member of the profession, we are a privileged group, and we are public citizens having special responsibility for the quality of justice. But our rules haven't spoken to that. And I'm going to suggest to you that if the first role of lawyers in society was the common good, the second role of lawyers was the pursuit of, representation of private interests, then I'm going to suggest the third is to broaden our sense of responsibility and to embrace our common law obligations. And I'm going to show you that we're already on that path. So here we have on my little timeline, we have Hoffman's rules in 1850. The ABA canons are adopted in 1908. They're elevated to rules in 1969. But here's where it gets interesting. It's in 1983 that the ABA first recognizes the responsibility of the profession to provide pro bono services. So we're already expanding our codified rules to reflect our common law obligation. And in fact, if I can jump ahead, in 1993, the ABA takes another step. It says, we recommend 50 hours. So it was not until 1988 that we go back that the comment to Rule 8.4G, discriminatory conduct, was adopted, and it's just in 2016 that that comment is elevated to a rule. But along that way, we've learned all this stuff about implicit bias. And so now what we know is that even if we stop conscious discrimination, we're actually not going to get to the destination of a diverse and inclusive profession, let alone a diverse and inclusive society, because we still have to struggle with implicit bias. And we can't rid ourselves, we can't intuit away implicit bias. We also know that there are shortcuts. There are things we can do. And so we have to move beyond just prohibiting conscious discrimination to something that will get us closer to an affirmative obligation to get us where we want to go. And I suggest to you that the next logical and incremental step is a proposed Model Rule 8.5. And that rule would borrow from language that we've already seen in the rules. Says it recognizes our role as learned members of society with an ethical obligation to promote the ideal of equality for all members of society. Every lawyer has a professional duty to undertake affirmative steps to remedy de facto and de jure discrimination, eliminate bias, and promote equality. So it is grounded in our notion of remedial justice. It picks up on the themes of what we are obligated to do as professionals, so I don't think there's anything controversial there in terms of lawyer responsibilities. Then it simply borrows on the model from the pro bono rule and suggests we do 20 hours, not even 50. I'm happy to start with 20 because I think the arc will continue. I'll take 20. And then it gives examples of such efforts, and the notion is to make it broad. We're not trying to make this hard. We're trying to make it easy. We're trying to reduce barriers to entry. And many of the things in the examples people already do. They attend CLEs. We work on pipeline programs. In our hiring practices, I know in my firm, we've taken steps to eliminate bias. For example, when you get your on-campus when you get your call back from an on-campus interview, we take the grades off the resume because we know that grades are weighed more heavily against diverse people than they are against against white men. So we've taken that out, that step. So we're already doing many of the things. My simple, non-controversial, incremental suggestion is that we update our model rules to reflect what has been our long-standing common law obligation to defend the ideals and values of our society, and I'd suggest paramount among them is equality. Thank you very much.